Under the Trump administration, U.S. immigration policies have undergone significant transformations, resulting in stricter enforcement and heightened scrutiny for green card holders and visa holders at ports of entry. Lawful permanent residents, who possess the legal right to live and work in the U.S., are now encountering more rigorous questioning and potential challenges to their residency status when returning from abroad. This shift in enforcement has raised concerns, particularly for those with prior criminal records, lengthy absences from the country, or weak ties to the United States. Understanding these evolving policies is critical for safeguarding residency status, avoiding potential deportation, and navigating the complexities of U.S. immigration law. Green card holders, officially known as lawful permanent residents, are entitled to live and work in the U.S., enjoy legal protections under federal, state, and local laws, and re-enter the country after traveling abroad. However, these rights come with conditions. To maintain permanent residency, green card holders must demonstrate strong ties to the United States through employment, property ownership, family relationships, and filing U.S. taxes. Extended absences, especially those lasting 6 months or longer, can raise suspicions about abandonment of residency. Absences exceeding 1 year require a re-entry permit to avoid potential denial of entry. Customs and Border Protection officers have increased their scrutiny at ports of entry, particularly under Trump-era policies. Green card holders spending significant time abroad may face secondary inspection, including additional questioning, biometric data collection, and record checks. Reports have emerged of officers pressuring elderly green card holders who have spent extended time abroad to sign Form I-407, which voluntarily relinquishes their green card. Immigration lawyers caution against signing this form, emphasizing that only an immigration judge has the authority to revoke permanent residency. Several factors have been identified as triggers for increased scrutiny of green card holders. Extended absences from the U.S. can raise doubts about the intent to maintain residency. Past criminal convictions, even minor ones, can result in additional questioning and potential deportation proceedings. Weak ties to the U.S., such as lack of employment, property, or family connections, also contribute to concerns about residency abandonment. The emotional burden and legal uncertainties associated with these stricter policies have given rise to a phenomenon known as self-deportation. Some green card holders, especially those with prior criminal records or unresolved immigration issues, are choosing to leave the U.S. voluntarily rather than risk facing deportation proceedings. The psychological stress of navigating an increasingly complex and unforgiving immigration landscape is pushing individuals to make this difficult choice. Adding to the evolving immigration landscape, President Trump introduced the Gold Card program, offering foreign nationals the opportunity to secure residency rights in the U.S. by paying a $5 million fee. This initiative has sparked controversy, with critics arguing that it prioritizes financial means over merit or contribution to the community, further skewing immigration policies in favor of the wealthy. International students and visa holders have not been spared from the heightened scrutiny. Holders of F1 and M1 visas are being closely monitored, particularly those engaged in activism or protests. A notable case involved a Columbia University student whose F1 visa was canceled due to allegations of supporting Hamas, prompting her voluntary departure from the country. This case underscores the legal risks associated with public activism for visa holders and the potential impact on future re-entry into the U.S. Travel warnings have become more common for visa holders. Immigration attorneys are advising green card holders, H-1B visa holders, and international students to avoid unnecessary travel due to visa processing delays, extreme vetting, and the risk of secondary inspections or detention at U.S. airports. Those who must travel are encouraged to carry documentation proving strong ties to the U.S., including tax returns, property ownership documents, and employment records, to minimize complications when re-entering the country. The long-term consequences of these stricter policies are profound, reshaping the immigration landscape and imposing emotional and financial strain on families and individuals. For green card holders and visa holders, staying informed and prepared has never been more important. Knowing one's rights, maintaining documented connections to the U.S., and seeking legal counsel when challenges arise are essential steps in protecting residency status. Keeping abreast of changes in U.S. immigration law and policies is vital to avoid unexpected complications. Maintaining strong ties to the U.S. through employment, property, and family relationships can help demonstrate ongoing commitment to residency. Legal guidance should be sought immediately if issues occur at ports of entry or if there is pressure to surrender a green card. Limiting international travel can also help reduce the likelihood of delays, additional inspections, or detention. This video presents a detailed explanation of the latest U.S. immigration law changes in 2025. Make sure to watch and stay informed.